Almost all set. Good morning. I'm Madeline Betts, Steering Committee, League of Women Voters. I'd like to welcome all of members and guests. We have special speakers today, Bill Anderson, and everybody, all of us know Bill, and constitutional lawyer, and Laura will introduce him. Sarah Beth Miller from the League of Women Voters of South King County will speak after Bill. So welcome. The meeting will begin. Here.
I get to introduce you. Yeah. Hi, I'm Laura Weiss, and I wanted to introduce Bill in case not everybody knew him. But originally, we asked Bill to talk about Supreme Court issues, cases before the Supreme Court right now. And he pointed out that nothing final has been decided in any of those cases that are still pending. So he wanted to talk more about what has gone before and how the initial judicial responses to Trump's requests were treated, and that's going to help us all learn about the judicial system and how it works. I asked Bill for a short bio, and this is what he wrote. I have to quote him directly. It is very short. Whoops, sorry. He says, I think all the audience needs to be reminded is that I am legally trained and after a couple of years in the executive branch have taught and written on constitutional law at the University of Washington and in various settings around the world for most of my career. So very pleased to welcome Bill. Thank you. I'm going to leave you the microphone.
Good morning, all, and I hope that, incidentally, when I come in here and so a speaker comes up and says, good morning, Horizon House always says, good morning, back. And it takes me back to the third grade, so if I say good morning, you don't have to answer that. That's, you don't even have to agree with it, for that matter. All right. I think the title of my talk is a wonderful, brilliantly written title. I thought about Supreme Court opinions. No, I don't know any of those. Supreme Court cases. No, I'm not involved in any of those. Supreme Court scandals. We don't really have very many of those. And so I got the most vague thing I could think of, Supreme Court issues. That allows me to talk about, do they get their robes cleaned by the same cleaner every week, or, anything I want. Those are issues. So, and then not all Supreme Court opinions are not even important state Supreme Court opinions, but issues, but some. So this is a very carefully drafted title, not to tell you very much. As Laura said, I have this annual talk I give about summarizing what the Supreme Court did in that term, and this year I've not given that talk because I just haven't any clue as to what the Supreme Court did in the last term. And most of the pending cases that you read about in the paper every day are not yet fully resolved. They're in some indefinite intermediate status. We don't have rulings on the merits. And we all, for example, read about the birthright citizenship case. We all thought that the Constitution said if you were a human being and you were born in the United States, you were a citizen. We thought that's what the Constitution said. Well, the current president says, no, he doesn't believe that. Well, that case is in the system someplace, but it hasn't gotten up to the court yet. So we don't know what they're going to do with that one. And many other cases have been tried at the lower court level that haven't reached up, and until they get to the top, we don't know what the court's going to do. So it's just uncertain to me what's going on. I don't like what's going on because of the uncertainty, but it's nevertheless we've got to work with it. So I thought what I'd do is two things. One, quickly, just to run you quickly through the court structure and how that works, and where the cases go and why they get stopped in this place and that. And then I'd like to take one case that's coming up. It's been argued already. It was argued last month, but we'd have no decision. And that's the case coming up out of Louisiana on a redistricting case. And it'll show you, I think, in a very brief summary, how complicated some of these issues get in terms of the doctrines we have. Well, just if I can operate this gadget, Nick explained it all to me, how to make the things. There we go. Most cases start out in some kind of a trial court, and I'll use the district court, court of appeals, and Supreme Court as the labels that come from the federal system, but most state systems have the same kind of thing. We have a trial court called a superior court, and then we go up to an appellate court, and then the state Supreme Court. So most systems will have these three levels in it. At the district court level, the trial court level, what you have is a trial. Now, a trial is what you see in the movies and in the novels. There will be somebody complaining about something, and somebody will file an answer saying why they don't think the complaint is valid. Then there will be some kind of a trial, and the trial usually has witnesses and cross-examination and documents and all that stuff. What you see in the movies, that's a trial. And then after the trial, there may be a jury if there are facts in dispute. There will be a decision by the court, and the court then will, on factual questions, the jury ordinarily decides facts, and the judge decides the law, and then he or she renders a decision in the case and issues an order that one of the parties will have to stop doing something or start doing something or pay money to somebody or something. That is the standard trial level process. If you don't like what happened at the trial, if you're a party and you think the court got the wrong answer, then you appeal, and you go to the next appellate level in the system. And in the federal system, we call that the Court of Appeals. Incidentally, there are about 800 or 900 federal judges around the country in various places. Probably 10,000 or so state court judges. State court law is it's a much larger system, many, many more cases at the state level. They don't tend to get into the headlines of the paper the way the Supreme Court does, but it's a much bigger thing. Lawyers who work in this spend a lot more time in state courts than in federal courts. In the Court of Appeals, the process is entirely different. There's no trial, there are no witnesses, there are no documents introduced and all that sort of stuff. What you have is a series of what we call briefs. I don't know where that word came from. They're not brief at all. They can go on at endless length if the court permits it. And those are written statements by the lawyers on both sides about why the trial court is correct or why the trial court is incorrect. And those are documents 40, 50 pages long, full of case citations and all that sort of stuff. Because the needs of the appellate court are to find out whether, given the law that has preceded it, the decision of the trial court is consistent. And so that's why briefs are full of historical materials. The old cases require this, the cases require that. That's why the trial court is wrong. They don't talk all that much about the policy question. Is it a good idea? Is it a just outcome? They talk about earlier cases, and if you read one of these briefs, you'll know that they're just filled with brief citations. Then there's an opportunity for oral argument in most appellate courts. That's when the lawyers get up and try and persuade the judges that their briefs are really the only thing they ought to read. The real importance of the oral argument is that it allows the members of the court to inquire or ask questions of the lawyers. What about this case? What about that? Why did you slight this? Why did you overemphasize that? And isn't that inconsistent with what you said earlier in the paragraph? That's what judges like to have an opportunity to do. Then there will be a decision by the appellate court. No jury here, no witnesses to examine or cross-examine. It's all a bunch of lawyers in a room, a very boring procedure for most people. And then there will be, in addition to a decision by the court, something new, and that is an opinion. Most trial courts do not issue opinions. There are some these days in very complicated cases, and they may go on for 100 pages or more, but mostly trial courts just rule that you have to pay money to somebody or you have to stop doing something, and that's the end of it. There's no opinion. At the appellate court level, there is an opinion. That turns out to be a very important step in the process, because what other courts do with what happens in this particular case depends on what is said in that opinion, what cases are relied upon, and so on. And then there's an order from the Court of Appeals. Now, if you don't like that, that's really the end of the process for most litigants, because in the federal level, you have no right to appeal to the Supreme Court except in a very narrow range of cases. Almost all cases taken by the United States Supreme Court are taken at their discretion. So there may be several thousand requests every year from parties who are offended by what happened at the Court of Appeals. But of those several thousand requests, the court can only grant about 80, maybe 90 cases. So that's all they can hear in a year. So for most litigants, if you win in the Court of Appeals, that's the end of it. Win or lose, that's the end of it. Now, when you get to the Supreme Court, the process looks just like it did in the Court of Appeals. There are briefs, there's oral argument, there's a decision, and of course, there's an opinion and the final order. Now, the difficulty with what's going on today is that not many people know outside the legal profession what happens between these various elements. For example, if you want to know what law applies from the time of the trial court order to the time of the Court of Appeals order, that may be months, could be years. What law applies? Does the law of the trial court apply, or do you have to wait before that applies, before that comes into effect? And that's the puzzle that we're in today, because we have hundreds of cases filed complaining about the president's executive actions, and they get to the trial court, and if the trial court says the president does not have the power to do that, the government then will appeal, and they will also ask the trial court for a stay. And a stay means that whatever the trial court decided is suspended and doesn't go into effect until after the appellate process is over. And you can see how that, in some kinds of cases, might make a lot of sense. The example to think about is the capital case, where the trial court says this man is guilty of first-degree homicide and he will be hanged next February. And so if he wants to appeal that, and it takes a year to get his appeal around, he doesn't want to wait till he doesn't want to be executed before the appeal is finished. So the court will stay that order of execution until after the appeal is done. And that's an easy case. But there are lots of times when there's some reason to believe that it would be better not to enforce the trial court opinion until after the appeal occurs. If the appeal occurred in a matter of weeks, it wouldn't matter, but sometimes these things can go on at length. So we have this operation about stays, and there are a whole bunch of different kinds of them in different settings, much too complicated for me to understand or for you to stay awake through. But by and large, the kind of case we read about in the paper every day is somebody files a claim, the president has acted outside his authority, the district court agrees with that person and orders the president to stop doing that, and then the government files an appeal and asks for a stay of that opinion until after the appellate process is finished. So what's the law at that point? And usually the basic concept of the stay is that it sort of obliterates the trial court opinion or holds it in suspense until after the appellate process. It tries to maintain the status quo until the appeal is finished. And if you think about what that means, those words mean, it means that the person, the citizen complaining initially has to wait until the appellate course is finished, because the order he won from the district court is sort of held in suspense until after the appeal is finished. And that means that if he's complaining that the president sent National Guard troops to Portland and the court says you can't do that, he can do that until the appeal is finished, because there is no trial court opinion in effect. If the plaintiff is the complaining party is a employee that got fired by the government, and the district court says that was a wrongful firing, and the government appeals and asks for a stay, if the stay is granted, he's still fired until the appeal is finished. So it's a very consequential thing in some of these cases. And the length of time between the order of the trial court and the order of the Court of Appeals, or between the time of the order of the Court of Appeals and the order of the Supreme Court, that can be very lengthy, and lots of consequences can happen. So the stay process is difficult. The rules about stays vary all over the lot depending on what setting you're in and what rules you're looking at. But basically what the court asks to grant a stay has to find is that the appeal is plausible or not complete, but it is nevertheless a reasonable appeal. There is some chance that the trial court might get reversed, and that there will be irreparable harm if the stay is not granted. And in the capital punishment case, that's a pretty good example of irreparable harm. So the idea is, does the person asking for the stay be able to show some reparable harm, or does the other party show some irreparable harm? Yeah, and so it's a complicated thing, much left to the discretion of the court asked to grant the stay. So that's kind of where we are in a lot of these cases. The government has appealed unfavorable verdicts in the trial courts. The government has asked for a stay. The court usually grants a stay. And so the parties initiating the litigation just have to wait until the appellate process is through, if that takes months or years. And in the meantime, the law before the trial court opinion handed down is in force, and that's kind of the way it works. So think about a stay as a temporary suspension of the trial court order if it can be shown that there's a plausible appeal possible and that there will be irreparable harm if the trial court opinion is carried out immediately. That's where we are with an awful lot of decisions today about all kinds of things like the birthright citizenship case and a lot of other things. And that's why we have some uncertainty about what the court's going to do. We're waiting for this process to continue. I can't think of a way to summarize the stays, but what I put in this chart is some notion that if there's a substantial question about the trial court's legality, and if there's some irreparable harm on the part of the person moving for the stay or the other party, then the stay might be granted. If not, the trial court opinion is the rule, is the law. I just wanted to mention that because I think that you may wonder why these cases don't get decided. And they don't get decided because they're in the middle of this process somewhere. We're in this interregnum between the decision of one court and the decision of another, and the court has decided to keep the status quo until we get that process finished. Probably a good system in most arrangements in the legal world. Not a very good one for an aggressive executive like we have. It leaves a lot of people in serious difficulty. You know, if you're a fired employee and you get a decision from the trial court that you were wrongly fired, but you still get fired because the government asks for a stay, and it may be a year before you get the trial court order executed, and you have a year without a job. And not only that, but there are other kind of things that happen to your career and happen to your family and happen to the agency in that year. So it's not a costless system. It is quite costly to many people, and we shouldn't have it done the way the courts ought to be much less generous in granting stays than they are. Well, that's just a little technical stuff. The substantive issue I'd like to address for just a few minutes is this redistricting case that's coming up from Louisiana. It's been before the court twice. They've had oral argument last month, and we got some clues as to what the justices think about the case, but we won't get a decision until sometime in 26. But think for a minute about the way we decide on congressional districts. Here's a state that has 9 citizens, and they're lettered A through I, and we're told that the way the population works out, this state is entitled to 3 representatives in Congress. So the state's job is to draw a map in which these 9 people are divided up into 3 districts, and that will be what that state has. And so, and you can draw the map in lots of ways. You could draw the map this way, which B, C, and F turn out to be in the northeast district of the state. D, G, and H are in the southwest district in the state, and A, E, and I are in the central district. And that'd be one way to draw the map. You can draw the map in many ways. Here's another way. And these days, the only bottom line legal requirement is that you have the same number of citizens in each district. So this map, for example, would be fine. And there are some objective reasons, some objective criteria by which these things are done. For example, the geographers and the political analysts will tell you that contiguity is one. It doesn't make much sense to have a district when part of it's in one end of the state and part of it's in the other end of the state, because that's impossible for those folks to get together. It's impossible for the representative to campaign on one side of the state or the other. And so contiguity is one of the criteria that you might use in drawing sensible districts. Compactness is another objective criterion about how you should do that. It's better if the people in the district are close to each other rather than strung out across the state. There are other criteria like recognition of existing government boundaries. You don't want a district which crosses over a county line or sometimes it's a matter of boundaries which encapsulate interest groups. The cattlemen in one side of the state ought to be in a different district from the sheepmen on the other side of the state. If there are districts, areas like that have common interests, they should be sort of relevant in drawing these things. So there are all kinds of objective things to do it. Now, apart from objective things, one of the critical elements is the political consequences. And if you think of these 9 citizens as members of political parties, suppose, and this obviously is much too simplified, but suppose the 9 people were as represented like this. You ask them what their political affiliation was, and you got 6 of them who said, well, I kind of lean Republican, and 3 of them said, well, I kind of lean Democratic. Does that make a difference in how the district line should be drawn? Here's one plan. We'll call it Plan A, that you look at and say, well, you've got a northern district that tends to send a representative to Congress who's a Republican. And you've got a central district in the state, and they tend to send a representative to Congress who's also a Republican. But in the southern district in the state, the representative they send to Congress is likely to be a Democrat. Now, this can't be precise, obviously, but just an illustration for talking about. And for most people, that seems like a sensible idea. 2/3 of the people in this state seem to lean Republican, and 2/3 of their congressional delegation is Republican. And 1/3 of the state tends to lean Democratic, and 1/3 of their representation in Congress is likely to be a Democrat. So that seems to a lot of people to make a lot of sense. But these lines are drawn by whom? In most states, they're drawn by the state legislature. And the state legislature may say, well, let's see, in the state legislature, we've got 6 Republicans and only 3 Democrats, so we can draw whatever lines we like. Let's see if we can't augment the power of our party. So let's draw the lines as in map B. Now here's a map in which nobody's moved, nobody's changed their position, nothing's happened except the lines have been redrawn, and now it turns out that 100% of the congressional delegation that state sends to Congress will be Republican. And there will be no Democrats sent. And the Republicans said, that's a terrific system, and let's draw the lines. Map B is the thing to do. Map A is much too egalitarian. Map B is much better. And isn't anything wrong with that? Any legal constraint? And the answer that might surprise some of you is that no, there's no legal limit on that. And if that's all that's involved, the court has many times, and most recently in 2019, had a full-scale attack on what we call partisan redistricting, and the Supreme Court said that is not something the Supreme Court wants to be involved in. It's just not a judicial question. It comes and goes. The Republicans are in charge one year and then the Democrats the next year, and it comes up and down and back and forth. And we don't want to get involved. That's not something judges know much about. Even though in that particular case, the most sophisticated case that's come up so far, there were some elaborate scientific formulas that were used to show that this kind of distortion was not a good idea. And the court said, I think Justice Roberts said, that's gobbledygook. And in a bit of sort of self-praise, he said, lawyers don't deal with gobbledygook. Where did that come from? We don't deal with other people's gobbledygook, and this is mathematical gobbledygook, and we don't do that. So he threw it out and said this is not a judicial question. So the answer to the question of whether this is okay or not legally to have this kind of distortion or this kind of emphasis of one part or another seems to be, okay, there seems to be right now, today, we hope someday it'll change, but right now it's okay to do that. Another characteristic of the voters is not just their political affiliation, but their race. Suppose you look at these people and they say, well, and we'll use white and black. The categories are more elaborate than that. But I think the notion here is that suppose you have your 9 citizens and you identify who they are by race and they turn out to be this way. Again, you might have a system in which you just draw these 2 lines, and in the Northern District, they're going to send a representative to Congress that probably favors white interests, and the same is true of the Central District. But in the Southern District in this state, they will probably send somebody to Congress who's more sensitive to black issues. And a lot of people say, as they did earlier, that's a fair system. 2/3 of the people are white, and 2/3 of the congressional delegation leans in that direction. 1/3 of the people are black, and 1/3 of the congressional delegation leans in that direction. So that makes sense. Well, but who's in charge? Well, if you ask who draws the lines, and if the lines are drawn by state legislatures, 6 of them are likely to be white, as we've seen. And so they might decide to redraw the lines this way for Plan B. And what does that mean? Well, again, nobody's changed their race, nobody's changed their location. Nothing's happened except the lines have changed. And now it turns out that 100% of the representatives that state sends to Congress will probably reflect white interests, and none of them will reflect black interests. So the question is that legal? If we can't attack these kind of systems because of their partisan line drawing, what does it mean if we get into racial line drawing? And here we have another set of rules that come into place. And those rules are not congressional rules, not constitutional rules, but rules deriving from Section 2 of the Voting Act that Congress passed. And the Voting Act says you can't draw district lines that discriminate among people on the basis of race or color and some other categories. So now we have not 14th Amendment stuff about equal protection, but we simply have a statute in Congress that says you cannot draw district lines that discriminate against people on the basis of race or color. Well, what's happened to that statute? It was passed originally in the 1960s and 70s, been re-amended and interpreted many times, and right today it's in a situation where the court is saying that if you have the right conditions and you come up with a Plan B that dilutes or discriminates against people on the basis of color, then we will redraw the line for you. We will, if you either do it under our order, if you don't do it, we'll do it for you. And we'll get you back to the map A here where the racial discrimination is not present. Okay, so that's Section 2 of the statute. And we have still nothing beyond that at this point. The reason the Louisiana case is that which we'll get a decision on sometime in 26 is interesting is that the court has heard that case once and asked that it be re-argued the next year. That tells you that they couldn't quite get their hands around it, didn't have a decision, didn't have a majority view on it. They wanted to think about it a little more. But in the course of asking for re-argument, they asked the parties to address the question, and this shocked a lot of people. In your briefs that you have to file in this year, would you please address the question of whether or not Section 2 of the Voting Rights Act is itself constitutional? And that's, well, wait a minute, how could that not be constitutional? And the answer is that the court has been chipping away at the whole concept of affirmative action in some cases last year, affirmative action in higher education and in some other areas. And the court seems to be flirting with the principle that affirmative action is a bad idea because it requires racial discrimination, but it might be necessary in some circumstances for some period of time, but not all circumstances and not forever. And so they shut down affirmative action in higher education last year, but some of the rhetoric suggested that the reason is the 14th Amendment, which proscribes that kind of discrimination, should not permit states or universities, in that case, from discriminating against race forever, just for a while, until we get the problem of racial misbalance solved. So, and that time is over for higher education, so you can't do it anymore. And the question presented to all of us by the court's suggestion that we look at Section 2 of the Voting Act and ask the question whether it might violate the 14th Amendment means the court might be saying, we usually, under Section 2, we've prohibited racial line drawing in the boundary cases, but that's the use of race, which we don't like to use at all. And it may be okay in some circumstances, it may be okay for some period of time, but not in all circumstances and not forever. And the suggestion of that question is that the court might be about ready to say that Section 2 of the Voting Rights Act has used up its promise, and it is now going to be regarded as itself in violation of the 14th Amendment. So you see the kind of complexity that the court is dealing with here. On the one hand, we have the Voting Rights Act, which requires a map to be redrawn to get back from map A to map, from map B to map A. It requires it. And the 14th Amendment, which prohibits it. So what is the court going to do? And that we don't know. But that's the kind of situation you get into, and I think it's the kind of complicated and difficult case that we're going to have when that Louisiana case comes down, because that case last year was sent back to Louisiana to redraw the map. They had a map B, and the court said, you got to redraw map A. And so Louisiana did that. And then some white plaintiffs came along and said, well, wait a minute. You drew some lines on racial grounds, and we think the 14th Amendment prohibits that. So that's the case that the court has got. And there were oral argument last month, and some of the conservative judges said, we think use of race in any context is a bad idea. And so we think we're ready to declare Section 2 of the Voting Rights Act unconstitutional. Whether there'll be a majority for that, we don't know. But I think the case suggests to you that in one of these cases, there are a lot of conflicting considerations, conflicting values, and uncertainties as to what the right outcome is or may be. That's all I have to talk about this morning. And if after the other proceedings, if there are questions, I'll be around. I'm sorry I have no answers. Yes. The question is how things get from the state court to federal court. The federal Constitution applies all over the country. So if a state does something that violates the federal Constitution, you can file that claim, and the state court can hear that issue, but the final answer will come from the federal court. Yeah, I think that's usually the way it works. Okay, I'm going to turn this mic over to the next speaker, but I'll be around if you have questions later. Thank you.
Thank you, Bill. We'll continue with the second half of the program. Sarah Beth Miller will be speaking on a new issue brought up by the Washington's D.C. League about Arise, which is a campaign of protest about what's happening with executive reach and unconstitutional, they claim, things. Sarah Beth will come forward and will speak about this, Unite and Rise. And I'll give you a brief bio of Sarah Beth. Sarah Beth has lived in Seattle for 40 years, has been a member of League since 2016. Her last employment has been education psychologist for the Bellevue School District, and she is currently active in League's Youth Committee and Unit Liaison since 2018. Welcome, Sarah.
Thank you. Thank you, Madeline. And to the previous presenter, that was so enlightening. Thank you. I'm happy that I'm on the same stage with you. I am the unit liaison for the League of Women Voters, and League of Women Voter members among us know what that means. The Seattle-King County League is divided into 9 different units or chapters that tend to be focused on different neighborhoods. And one of our premier chapters is right here, First Hill Horizon House, where we have a number of members that are active. So that is what I do with the League, as long as being active in a lot of other committees and so forth. I am here today because Sandy and Madeline invited me to talk about a new movement, enterprise of the Federal League, the U.S. League, and it's called Unite and Rise 8.5. So that's what I'm here to talk about and address it rather quickly. There's a lot of information on the League website about it, but I also want to talk to you about what we, League of Women Voters of Seattle-King County, are busy with. So if you will give me a second to get this presentation adjusted here. I may need Nick. Well, I need my
You
presentation.
want to advance the slide? The big button.
Just advance it. That's all
Just
what
the
do you
big
know?
button will do it. Yeah.
Thank you. Okay. So here we are, Unite and Rise 8.5, League of Women Voters, Seattle-King County version. Okay. As I said, this is a national effort, a national enterprise, and it's up to local leagues to determine what to do with it. So, what is Unite and Rise 8.5? Essentially, it's an initiative to defend democracy. Where did the number come from? Well, it's estimated that 8.5 million is about the number of voters needed to bring about change through nonviolent protest. And this estimate is based on a finding by the Carr Ryan Center for Human Rights that is, nonviolent protests are twice as likely to succeed as armed conflicts. And those engaging a threshold of 3.5 of the population have never failed to bring about change. There is a bit of a qualifier there. I'm familiar with the study about the threshold of 3.5 that was advanced by Erica Chenoweth at Harvard. And she wants to restrict that 3.5 number because it's taken from protest movements in the 20th century. We're in the 21st century now. What's going to change? Okay. The League has set forth 4 pillars of Unite and Rise. The first one, of course, is legal and policy advocacies. And this is where the League operates to challenge unconstitutional decisions or proposals that they believe are unconstitutional. They advocate for electoral reform at the state and federal levels. And of course, fighting voter suppression is key. And finally, protecting due process is another element of the legal and policy advocacy. So number 2 of the pillars is public mobilization and coalition building. This is simply activating groups, whether they're short-term or longer-term plans, to do protests and activation and to lift up votes and get in touch with grassroots national and international organizations. Number 3, civic education and engagement. Well, that's who we are as the League, right? We educate and inform voters, and in that way, we empower them. This is done through public awareness campaigns, our voter registration drives, community forums, and so forth. We're connecting policy to its real-life impact, and we're giving people the tools they need to get what they need. This is all stuff that the League does in general, right? Okay, so Unite and Rise cleaves closely along with the usual League activities. The 4th of the pillars is democracy resilience, and this is about building and enlarging our infrastructure so that we are ready to protect democratic values and institutions for the long haul. Okay? I'm open to questions if anything is not clear. All right. So the way the League has organized this movement, Unite and Rise 8.5, is to divide it into playbooks. These playbooks are also called micro campaigns. And it's slated to that each playbook will last about 3 months. It'll be in effect, in operation, and that will be the emphasis. All of this is detailed greatly in the League of Women Voters webpage. But generally, Playbook 1 was in action from May to July of this year. And the theme was shifting the power narratives. The idea was that Playbook 1 would do a lot to lift up the voices of those who were impacted by decisions of the Trump administration, mostly immigrants, people of color. And also, they were to clarify and make well understood what's at stake by educating and mobilizing around voter suppression of the SAVE Act, the lack of due process for immigrants, and the impact of the budget reconciliation legislation, the big, beautiful bill. What did we decide to do as the local, our local League of Women Voters, Seattle, King County? What are we up to? So for Playbook 1, the first thing we did was we created a local committee. We have a Unite and Rise committee with about 25 members right now, still open for anyone interested, and we meet about twice a month. We try to come up with ways that we can examine and put into effect some of the propositions in Unite and Rise 8.5. We started out, we wrote a cover letter that we could send to friends and family to join us. Now, one key point about Unite and Rise 8.5 is that it's not necessarily restricted to League members. We want to activate more than just the League population. So the idea was that we would send out a commitment pledge of all that we plan to do, and we would allow people who are not League members to join us. They certainly were allowed to join us, and that would be wonderful, but it was not a necessary condition. The other pledge that we made to them was that if they gave us their signature and committed to some form of actions, we would update them every 3 months as to what the next playbook was going to focus on. So part of what our committee decided to do was print up little Unite and Rise 8.5 business cards to distribute, and also some posters for use at tabling events. Here comes Playbook 2. Supposed to be taking place August to October, so we're coming to the end of this playbook. And the theme here is holding power accountable. How do we do this? Well, we defend and advocate for voting rights and fairness in mid-cycle redistricting. We advocate for economic justice, budget reconciliation issues, Medicaid, SNAP, ICE funding, and appropriations. Next, we encourage everyday democracy actions. What are those? They could range from writing a postcard, sending a letter to the editor of the paper, making a phone call, or joining in participating in a protest. Number 4, we are building a nationwide network of government and election observers to observe in local proceedings, such as school board meetings and so forth. And 5, highlighting the role of the courts. Ta-da, you've done that today in our system of checks and balances. You might be thinking, aren't these things that the league does every day anyway? And yeah, they are. But there's more of a focus, more of a concentration on networking and spreading the word and raising our profile in the process. So what kind of things have we, with the local league, done for Playbook 2? Well, we had widespread participation in the No Kings protest. We had a tabling event at the No Kings protest at the Seattle Center. We, of course, continued sending postcards to Congress on a lot of issues. And we have continued with our bi-monthly Unite and Rise 8.5 meetings. We're on to Playbook 3 now, November to January of 2026. And here the emphasis is on building sustainable partnerships. So the way the league defines power in this case is that it's the ability of people to shape the decisions and the systems that will lead to their future and affecting their everyday lives. Partnerships are the thing that make power possible. No movement for democracy can thrive without coalitions, alliances, and expansion through connections that are even beyond our existing networks. What are we at the League doing about Playbook 3 this month? So far, we planned a Heroes Day celebration for election workers at King County, and we held a work party to prepare posters and cards. We celebrated the day by delivering to King County Election Building loads of baked goods and hundreds of cards that our league members had written of appreciation. And we decorated the place with posters and just had a party to celebrate them and to show our appreciation. It felt really good. Also, League of Women Voter units are going to be partnering with local food banks and or social service organizations to distribute needed goods to struggling families in our communities. We will continue our bi-monthly meetings as an incubation for new ideas and new approaches. And here is a sample of our Unite and Rise business card. This is side 2. That's side 1. Okay. So that is my summary of what Unite and Rise is and how it's been operating in our local leagues and within our units. Any questions or thoughts spring to mind? Yeah.
I have a question
Okay.
about standing up against L-126, the movement that's about right now. Does League provide any signage for us to carry while we silently don't interrupt their process?
Good question. That might be a question for our Voter Services Committee, but I will find that up. And that was, L, you defined that. What?
I think it's 126.
Yeah.
I have a very faulty memory.
Yeah. Okay. Okay, good question. I will see what I can find out about that. Anybody else? Yes, sir.
Do you have any do you have any ongoing relationships with interacting with our actual senators and representatives and council members, where you in fact don't just carry forward the complaints, but carry forward ideas that they may not have had that can influence the politics of the situation?
That's certainly a way that we can be useful and amplify those our positions on those. We do have the legislative effort where we go to Olympia and do lobbying and meet with senators and representatives in that way. But I know that other leagues around the country are, one of the things that they want to achieve is sort of in-your-face time. The League of Kentucky was planning to go and see Mitch McConnell with a group of folks. Right. And so that's another branch that could spring out from this tree, but that's a fine idea. Mm-hmm. Okay. Yes, go ahead.
How is the League maintaining its historic tradition of nonpartisanship? These actions that you're describing can easily be construed as partisan.
Yes, critical question. Thank you for asking it. Nonpartisanship is essential. In fact, that's part of what makes us more flexible in making alliances and building our network, that we're not rigidly for particular candidates or for particular political parties, but we are rather here to inform and enable voters. So we want to make a point of that and remind ourselves of that essential League feature. But it's something that we have to be careful about and, monitor every situation as it comes along. But underscoring nonpartisanship is, I think, essential to building what we can do in terms of enabling democracy. Yeah. Laura? Yeah. Do you want to?
Just in response to Mary's question, at our last meeting, I talked about the background of League action, like participating in No Kings. Back in April, the National League declared a constitutional emergency, that constitutional crisis.
Yeah. Mm-hmm.
And that felt that the actions of the current Trump administration were so blatantly in defiance of the Constitution that enabled, we were not supporting candidates, but we were supporting the Constitution. And so the action has been based on that belief.
Yes. Thank you. Yes, over there.
I was just going to add the idea that what League has done and is doing, and especially this group, is encouraging to vote. And that is a fundamental step of continuing our democracy and giving women the same right to speak and vote as other people.
Always, definitely. Another microphone.
So much easier than yelling.
No kidding.
I joined some other otherwise unaffiliated people at a couple protests, but at those protests, we distribute declarations of independence, the U.S. Constitution and its amendments as suggested by League, supporting the idea of supporting the concept of making this pro-constitutional issue, not a political issue. I appreciate that right now we have a political leader who's, I feel personally, corrupting these ideas, but I'm not against POTUS. I'm against breaking up the Constitution.
Yeah. Yeah, thank you. And I want to just circle back to what Laura had said. One of the impetus behind Unite and Rise was the fact that the League came out in spring, April maybe, and declared that our position was that this country is in a constitutional crisis. What are we going to do about it? And that is what has given rise to Unite and Rise 8.5, mobilization around that fact. And we have been very active this election year, this November and October. We've done tons of tabling around the county and spread this word. We always have stacks of constitutions, and they go like that. They're gone, and no matter how many we have, along with other League, paraphernalia and pamphlets, which are also valuable, but the interest has been enormous. I haven't seen tabling events that were this crowded in a long time, and our current Seattle King County League membership is up to 600 now, which is quite a growth, and more people keep joining every month. So we want to stay focused. We want to stay active. I commend you. Sandy and Madeline were just telling me this morning that you guys are out on the corner of Seneca and 8th or 9th with both with posters. And that is the kind of visibility that heightens our profile and brings people, to on our side and gets them interested in voting and what's going on with government these days. And there's just obviously with ICE protests and Medicaid and food safety and all of those issues, there's just a lot to be active about. I will say too that when we talked about making alliances and expanding our connection, I participated in a phone call last week with some other folks around the country who were doing this. And a woman from Utah said that their league had made an important connection with Mormon women who were very adamantly opposed to redistricting in Utah. So that was a great nonpartisan alliance that the league could make with a group that we might not think were compatible with many of our ideals. But that's the kind of thing we're going to have to do to build our resistance to the constitutional crisis that's occurring. I wanted to just quickly address future actions, next steps, which some of you have brought up. We will continue to have our Unite and Rise 8.5 committee meetings twice a month. We're going to participate in monthly community calls, which are listed on the league website. If you look under Unite and Rise 8.5, they have a monthly community call, and it's wonderful for hearing what people around the country are doing. They also provide trainings, and I think there's one tomorrow. We're going to continue to gather ideas and experiences from our units and other sources to expand our reach. And we are always seeking additional tools and resources from Unite and Rise 8.5, and there's a link to that, to the League US website. And it's just chock full of things you can do. How to write a letter to an editor, how to organize a small protest, how to make a video to support what you're doing. Just a variety of things that are doable and achievable for a small group. So, okay, that concludes. Oh, yes, sorry.
Very specific. One other specific question. And as I understand it, that your letter writing campaign to all over the country,
Yeah.
that it was hooked into some kind of an organization where the leader was at the School of Communications or something.
Oh,
And I was wondering who that was.
yes, Common Power. Or is that what Common Power is another organization.
Oh, and who is the person that?
David
Oh, David.
Domke. Domke, I think.
Oh,
Domke, yeah.
okay. Spell that once more if you.
Okay. First name David.
David.
D as in donkey. O.
Uh-huh.
M as in man.
Uh-huh.
K as in kangaroo.
Okay.
E as in elephant.
Domke. David Domke.
Yeah.
Thank you so much.
It's hard. It's a hard name. Okay. Okay. Any other questions? Oh, I do. If any of you know or meet with Adele Reynolds, please tell her that we are starting up a brand new West Seattle unit. We've got a dynamic vice president, Janet Leonard, and she's ready to go. So, good news. Okay. Thank you all.
Thank you so much. My goodness. Lots of good information for us to keep going with these issues here. We're going to have a small membership report. Oh, from Sandy? No?
We do Q&A for Bill, of Bill's presentation.
Sorry. Bill, thanks for presenting. Forgot to mention it before.
But he had
Any questions for Bill? I see none. Very informative, so informative that gave me a headache. Thank you very much for coming.